Welcome everyone, and thanks for joining. This is our third of four webinars that are closing our dissemination of research from our project AI for English Law. And this project is funded by UKRI as part of the Next Generation Services Stream, which is an industrial strategy challenge fund program. The goal of this program as a whole is to stimulate research intended to facilitate the adoption of AI in high-value service sectors. And the sector that the research team based at Oxford University have been focusing on is the legal sector. And we view the issues around adoption of AI in legal services as a cluster of interlinked or complementary factors. And so our project has chosen to focus on 6 complementary sets of research questions that try to address this cluster of issues in parallel. So the research questions we've looked at are the technology itself, regulation of the technology, business models of firms using technology in legal services, skills and training necessary to deploy technology effectively in legal services, and the ecosystem for law tech startups. In this webinar, we'll be focusing on the legal and regulatory framework, and also on some aspects of the education and training that are needed for lawyers and technologists working in the sector. So the outline of the structure for today's session is the first hour and a bit. We're going to be having presentations from the research team members. And then in the second part of the session, we'll be having a panel discussion, and then there'll be Q&A following that. So let me just say a little bit about the structure of the sessions. So as I said, today's presentations focus on the legal and regulatory issues relating to the deployment of AI. And we begin with the promise of using technology in legal services. And one of the most commonly cited motivations for deploying technology is to try to facilitate access to justice, because we talked about last week people being priced out of the legal system by the costs of legal services. So there's an opportunity there to facilitate access to justice. And our first presentation by Jeremiah Adams-Prassel in the law faculty at Oxford looks at the status of access to justice in our constitutional framework and tries to understand from a legal point of view how the norms underpinning access to justice relate to policy choices, for example, about the deployment of technology in legal services to facilitate that. We then go on to our second presentation by Abby Adams-Prassel, who's in the Department of Economics here at Oxford. And she explores the use of online judgments as a way to facilitate access to justice. So this is something that is much talked about, is the provision of data online can facilitate access to justice through technology for citizens. But how does it work in practice? And she's going to explore a case study based on judgments in the employment tribunal available online. We then move to looking at one of the legal parameters that relate to using technology to facilitate access to justice, and that is the question of privacy and how that is protected, citizens' privacy, how it's protected, and how the legal rules surrounding that interact with access to justice data for firms that are using the legal technology business model, that is, are designing and implementing law tech products. So that data needs to be analyzed in order to be able to provide scalable solutions to facilitate access to justice. But how can that be done in a way that respects the privacy of participants in the legal system whose data is captured in those data sets? And that will be covered by Sturgis Adinlis and Hannah Smith from the Oxford Law faculty, who'll be presenting part of a wider body of work that they've been doing on this and related questions as part of our project. Then the final presentation, we move from this focus on the legal parameters for facilitating access to justice in the legal system using technology to broader questions about how the law and the legal system will have to adjust to the use of AI and other advanced technologies in society more generally. And this is one of the questions that are covered in our skills and education component of our program, and are objects of research in their own right. And the presentation here will be given by Becca Williams in conjunction with Tom Mellom. So Becca's in the law faculty, Tom's in the computer science department, and together they've been working on the education and training component. Becca is going to give an overview of the ways in which law will need to respond to the deployment of AI in society, and then zoom in on one particular aspect, that is judicial review of algorithmic decision-making by public bodies. Then in the second hour, we'll move to our distinguished external panelists, the first of which is Sir Ernest Ryder. He's currently Master of Pembroke College, Oxford, but before that, he was a senior member of the judiciary. First as Senior President of Tribunals, and then latterly as a Lord Justice of Appeal. So he has a very hands-on view of the ways in which technology might be able to help in the legal system. He's published and lectured internationally on many legal topics, in particular focusing on the role of a modern judiciary, the leadership and governance of justice, and cultural conflicts in justice. And Ernest is going to give a short response or reaction focusing on the first two of the research presentations. Our second panelist is Dr. Natalie Byram, who's Director of Research at the Legal Education Foundation, where she leads work on their Smarter Justice programme. In 2020, the Foundation announced the development of a new strategic initiative, the UK Access to Data Justice Lab, which aims to improve the evidence base for what works in assisting individuals understand and use the law, and address gaps in their research about the outcomes people secure in relation to their legal problems. So in doing this work, in leading this work, Natalie has a great deal of expertise and insight into the issues that we're focusing on, in particular in relation to the third of our presentations. She also sits on the Administrative Justice Council and was seconded to the UK government as expert advisor on open data and academic engagement. And her final report at the government set out a series of recommendations for ways in which the data architecture underpinning online court projects should be developed to ensure that access to justice is upheld and enhanced. And our third panelist, joining us at an unconscionably early morning hour, so it's just around 6 o'clock in the morning where he is in Stanford on the West Coast in the US, is Professor David Engstrom, who's a broad-ranging scholar whose interests encompass public law and the design and implementation of litigation and regulatory regimes. He's currently working his research is focusing actually on the intersection of law and AI through a project on the effects of continuing advances in law tech on the civil justice system and the governance, lawyering, and access to justice challenges posed by AI. So he's well placed to respond to and react to many of the issues that are being discussed today. So I've introduced everyone here, and I'm really looking forward to the discussion. I'm going to now hand over to Jeremias for the first of our research presentations.
Thank you, John, for this kind introduction, and thank you everybody for joining us. I will just try and get my slides up. So really, the first few papers we're going to see and we're going to discuss this afternoon come out of Work Package 2, which, as John has already said, really thinks about the sort of system level infrastructure we want to think about. And one of the key promises, but also, potentially some peril involved in the digitalization of the justice system, is access to justice. Now, it's quite easy to, as it were, sketch out what some of those advantages are. Think about, very easy access to court buildings without having to travel there. It's very easy to sketch some of the potential disadvantages in terms of lack of access to digital infrastructure, for example. What's much more difficult is thinking through these various advantages and disadvantages in the context of access to justice and coming up with some sort of system level infrastructure that would then allow us to actually evaluate and understand the broad constitutional applications of digital change. Now, we should add that even though digitalization has been one of the biggest changes in the justice system in recent years, it's only one of various other things that are happening. And so what we need is some sort of infrastructure that allows us to evaluate the advantages and the disadvantages. And the first thing we had to do as part of the project, therefore, was come up with a robust framework for access to justice, and one also that lends itself to some form of empirical quantification, to some form of robust empirical measurement. And so what we ended up with is, in a paper that's recently been published in the Oxford Journal of Legal Studies, thinking about access to justice through the lens of futility and through a new emerging doctrine of English administrative law called systemic unfairness. So let me just very quickly give you an idea of why this systemic unfairness case law is so important. The fundamental difficulty we've always faced with trying to think about system level operation of doctrines such as access to justice is that traditionally English administrative law has very much focused on individual wrongs, has focused on the individual harm suffered by a claimant, has focused on the individual mistake made by a particular decision maker. Whereas, of course, when it comes to access to justice, we're not necessarily interested in a single decision or a single wrong. Indeed, there are other avenues of pursuing such issues. But what we're thinking about, is there a way we can, in a legally coherent way, look at the overall system? And when we started sort of to explore this, we came across a series of cases that essentially start thinking about systemic challenges in English administrative law, systemic challenges that link risk of unfairness to something that is inherent in the system itself. As you see on the quote, the second new emerging scheme thinking about judicial intervention to obviate in advance a proven risk of justice which goes beyond individual aberrant interviews or decisions and inheres in the system itself. That's Lord Justice Sedley and Refugee Legal Centre. And so really what we set out to do in this paper, try and think, can we use this notion of systemic challenges to think about designing governing structures for individual redress online? And that then, drawing on a recent case in the UK Supreme Court called Unison, we really saw that crystallize into what in Unison the Supreme Court referred to as the risk of futility. Essentially this idea that you might have a meritorious claim, but overall the system incentives are set up in such a way that it essentially becomes futile or irrational to bring a claim. And so the argument we then make in the first part of the paper is to say we can actually link this notion of futility essentially to the inability to vindicate a meritorious claim. And that then becomes crucial in working out how technology deals with access to justice. Will it lead to further inability to vindicate meritorious claims? Or, the big promise, will it do the opposite? Will it actually make it much more straightforward to vindicate meritorious claims? And so really this notion of futility becomes the key to modeling claimant behavior and think about both individual and system level incentive structures. And the way we boil down our analysis of any system is that we think about access to justice risk as essentially composed of two different factors. And that then is our framework. We think first of the risk of futility, and then we look to the cost of futility. Because the important thing is that no system can be completely without risk. And so just looking at risk of futility alone isn't enough. It's only when there's a risk of futility compounded by very significant cost of futility that we argue that serious access to justice considerations are at stake. Now, we've only got about 10 minutes or so for each paper, so I'll just try and very quickly unpack what we mean by those two components. There's lots more individual elements out there. Very happy to go into them later in discussion as well. But let me just give you a quick idea what we mean by risk of futility. We think about risk of futility through two different components. We think about it first as a series of individual incentives, and then we also think about system level incentives. And in both of those, digitalization can play a significant role. So let me give you just an idea about the individual incentives, right? So essentially we're using simple economic models here, using choice and uncertainty as the framework for understanding individual incentive structures. So, for example, there's a large literature out there thinking about what are the options actually available to an individual in terms of affordability. Very expensive, have lawyers, actually go to court. Well, technology could potentially, in ways that Abby and others will talk about, make that much more affordable. There's also questions of ability. Can you actually technically deal with complex structures? And of course, there's also then when you think about what's the net benefit of engaging with a particular litigation alternative, and when you think about the costs relative to benefit. And of course, here again, we see digitalization having potentially very significant impact on enabling individuals to launch claims by bringing down the costs. Similar sort of issues when we think about the system level incentives to ensure that a meritorious claim can actually be vindicated. Essentially boiling down, for example, to the question of, can the law be applied correctly to the facts of a case? That includes in English law, for example, the requirement to be able to put a case effectively, right? That could need a hearing when important facts are disputed, or when it's very straightforward, actually, it might not be necessary to do that. Other questions surrounding representation and legal aid, where you've got very factually or legally complex issues. An individual might not actually be in a position to present their own claim. Again, various ways in which tech could very much help here. Also, and this has certainly been in the first wave of digitalization, we've seen quite an extensive use of technology simply in case management, just making sure that actually becomes more straightforward in terms of management actually deploying the resources of the justice system as efficiently as possible, and therefore increasing the chance, or in our terminology, lowering the risk of meritorious claims being vindicated. But as I've already said, it's long been recognized that no system can be completely without risk. And so in addition to risks of futility, we also need to think about the cost of futility, or the impact, if you will, of futility if there's this risk that a claim will not be vindicated. And again, we can follow quite neatly the structure of thinking about individual cost and system level cost. And what we argue is essentially that futility has really important consequences when the inability to vindicate a right has either very high individual cost, so think about imprisonment or very significant fines, but also high social costs. Right? This is the idea that actually litigation is a really important public good, particularly in a common law system. Also this idea that we've got significant positive externalities. Think about the deterrence, think about the importance also of precedents. As the Supreme Court reminded the Lord Chancellor in unison, the notion that there is no positive externality from litigation is refuted by the very idea that every single case has to cite and rely on lots of previous decisions. And so, again, in a sense, as a heightened review standard, for example, the larger the number of claims that would potentially be affected. I'm nearly out of time. Let me just give you one last slide, thinking very quickly about the broader implications and then leading over to Abby's paper. As I said at the outset, given the fact we're looking at very significant reforms to the justice system, digitalization really needs to be empirically scrutinized, needs to be very carefully researched, evaluated, thought through. And one illustration of that you'll see very soon in Abby's discussion is the online publication of tribunal judgments, which another paper will present to you discusses. Futility in this framework of risk of access to justice and the sort of cost of a lack of access to justice is not just a review standard in terms of accountability, both in legal scrutiny, but also in political scrutiny before Parliament. We think it can also be a really important guideline for future reform design, from data collection through to actually implementing some of these challenges. And several of our discussants, I'm sure, will also want to discuss that. That's it for me for now. Thank you very much indeed, and I will hand over to Abby to discuss the questions, the specific case study of the tribunal judgments.
Okay, excellent. So yeah, so on to me with a kind of example of what, of what some of these kind of theoretical access to justice issues might look like in an actual context of the UK justice digitalisation agenda. So this paper really arose out of this point that Jeremias made, that the UK justice system is currently the subject of a large number of reforms, many of which involve the kind of digitalization of previously, I'll say, kind of like analog processes. So we have reforms over the way in which claims are launched, both in terms of filing online, but also we've seen different reforms as well to, having to pay fees, for example, or go through different types of mediation before having access to the tribunal system itself. We then have, we've been speaking about reforms to the process by which claims are adjudicated. So for example, pilots of continuous online resolution or online hearings versus your kind of standard in-person with all parties co-located type formats. And finally, we also have had reforms to the process by which outcomes are reported, notably the publication of some judgments online. So, for example, in the employment tribunals since 2017, judgments have been freely available online, hosted on a government website. Now, if we think through these kind of myriad of different reforms to the process, it's actually uncertain what the net effect on access to justice is. So whilst a lot of these reforms have been motivated by, as John was saying, like kind of partly motivated by a desire to improve access to justice by lowering costs to the systems, potentially making it more easy for litigants in person, it's unclear what actually the extent to which some of those wishes are realised across the whole spectrum of claimants. So for example, particularly vulnerable claimants who don't have easy access to online technologies might find engaging in a continuous online process particularly challenging. And so I think one of the key things here that one must always be aware of when you're reforming key aspects of the infrastructure with which our society is governed by is really having this eye to the potential for unintended consequences. So given this heterogeneity in like kind of a priori what we might think actually might happen to particular types of claimants within the system, the key point I want to get across is whether these reforms are good or bad, or in terms of what their net effect on access to justice is, that's an empirical issue. It's not necessarily something that you can just work out by kind of thinking through on the one hand this, on the other hand that. Now, the problem with this about actually the evaluation of these reforms, the net effect is kind of uncertain. Problem is that actually access to justice data on the types of claims which are being vindicated and the outcomes that individuals are receiving is pretty patchy in the UK, and high quality survey data is infrequent. So that led us to actually think about the use of actually one aspect of that kind of digitalization reform, i.e. the publication of online judgments, as a bit of a treasure trove in itself for information on actually what are the types of claims which are being brought and to what extent is that changing over time. So to kind of, I guess, put it in a slightly more kind of, pithy way, so we've got the online, so the publication of judgments online is both an element of a digitalization agenda, but could it also be used as a tool for the evaluation of wider reforms? So since these went live in 2017, almost 80,000 decisions have now been uploaded as PDF or text files in an easily searchable database hosted on the gov.uk website. So you can see, for example, a screenshot here. So we were turning to this really because, as I said, public justice statistics are often highly aggregated and only available with considerable time lags in publication, which really makes it difficult for researchers externally to quickly evaluate the impact of these different reforms on different types of claimants. The key here being that, as we've just kind of explored, we know that some of these reforms, it's pretty likely that they're going to be good for some people. So we might indeed see a rise in caseload overall. But what about individuals who are particularly vulnerable in the system? And at the moment, public statistics aren't going to tell you that. Now, detailed surveys, which might get you some of that information, are rare and they're also pretty expensive. So this is actually incorrect now. So the last survey of employment tribunal applications was published a couple of years ago, but it's still the case that these surveys are pretty infrequent and can be themselves subject to themselves issues with who exactly is it who is responding to these surveys. So what we can use potentially judgments for, at least there's the potential for, is we can use kind of modern tools to scrape information about the characteristics of cases and claimants from the text itself. So in the paper, we just give a very brief overview to the pretty standard tools. I mean, you know, if you're like even a little bit tech savvy, it will probably take you an afternoon of a combination of Google and Stack Exchange to work out how to employ kind of freely available tools to actually extract information from judgments straight from the website, you know, with free tools and not even very much processing power. So, you know, and for underneath each decision, we've got these individual pages which give access to more metadata about the case itself. So, for example, the date the decision was, and various jurisdiction codes that case relates to, and then you can pull out information from the PDF or from the Word document itself to facilitate a kind of a more granular text analysis of information that is contained within the judgment. Now, so a couple of things here. So the data in, so there's a certain element, so as you kind of just saw from those screenshots, some of the information that you can get easily off of the gov.uk website is highly structured. So things like decision codes, decision dates, and country. However, when we turn to the judgments themselves, there's a huge amount of heterogeneity in format and content. The other thing is that the names of individuals and, you know, both the claimant themselves, but also witnesses are not redacted. There's potentially a range of very sensitive information about a large number of the actors who are kind of in this process, just freely available on the web. And not only and you know, there are issues if you're actually trying to do anything more complicated than just a word search on that. There's not really very much structure placed on exactly how these judgments are structured and put online. Now, so what we've got is we've got kind of issues with kind of just using some of this judgment data, if you like, off the shelf. But that also presupposes, if that's the only thing that you're looking at in terms of an issue with, if you like, using and operationalizing some of these wider uses of online judgments, kind of also you need to be really aware that these decisions actually can't provide a comprehensive account of all disputes. Okay, so for two reasons here. So firstly, not all cases actually make it to court, and in the context of the employment tribunals, in not all instances are written reasons requested. Okay, so we've only got a selected sample of cases that we've actually got the information on. And furthermore, the process by which certain judgments appear online is actually pretty unclear. At least it was to us when we were researching this. And so you do have a mismatch between the numbers of judgments that we have online on the gov.uk websites and the number of cases that are reported in the quarterly tribunal statistics. But this has not prevented these issues, both in terms of actually the nature of the judgment data itself and the fact that we don't actually have information on what is a selected sample of cases that we have information on, has not prevented private companies and researchers from trying to think about ways of harnessing, of harvesting this data in order to either build tools or try and understand the characteristics of the justice system at large. So, for example, a company, Solomonic, was trying to build various tools extracting information from judgment data. We've also heard instances of companies trying to build employment status predictors, for example, on the basis of information on whether a particular claimant comes down. Are they workers? Are they employees? Are they self-employed? On the basis of cases in the online database. I can see that I'm already actually running out of time, but so in the paper, I'll just kind of signpost you here to kind of the issues that we explore. So we kind of we go through kind of a series of reasons for why we might have some caution to actually thinking about the process by which these judgments made online and the extent to which we might want to restrict access to or the information contained in these public judgments. Because of course we have the principle of open justice, which requires opening judgments up to scrutiny, but it's not, it's not entirely clear what this means in practice. And also, in other jurisdictions, anonymization of judgments is routine. We think this is particularly important in cases like the tribunals, where we've got an inequality of bargaining power between the different actors in the process. And it's quite, and again, that there is already kind of anecdotal evidence of employers and actually using this database to actually kind of identify potential troublemakers or blacklist in advance. And there are, of course, broader legal considerations in terms of copyright, in terms of data protection and GDPR, which I'll leave it to the lawyers in the next presentation to explore further. Okay, I'm gonna, just because of the time. So in the paper, what we do is we analyze what we think of as existing sources of protection for claimants in terms of the uses of this of online judgments, ranging from blacklisting regulations, anonymity order, data protection rules, and equality law. And we find that the overall kind of package of protection that is currently available under the law isn't fully sufficient to actually kind of fully mitigate some of the concerns in terms of blacklisting and in like kind of, if you like, kind of abusive uses of personal data from judgments, in the current context. And what we also thought, and what we also explore at the end of the paper is really that one of the issues, why is it that these existing kind of legal safeguards that we have are insufficient? It's really because these existing safeguards don't actually control, give individuals control over the inferences drawn from that data, nor control over the use of that data in decision-making processes that rely on them. And so a kind of a key conclusion of this case study is really that we need to think more creatively about additional steps to regulate and to open up to scrutiny the processes by which kind of machine learning systems and kind of like big data systems of various forms are, like how is it that they are extracting, and where is the source of the various input data, including online judgments, but more broadly, and also this need for scrutiny over the process by which this data and these decisions are being made across various contexts. Right, I will stop there and hand it over to the next presentation to explore these legal issues in more detail.
And our next presentation is going to be by Sergios and Hannah.
Yeah, thank you, John. Let me just share my screen. So I hope now. Can you see my slides in full screen? Okay, great. Thank you. Today, I think with Hannah, we are really happy to be presenting this piece of work we have been doing together with John and Jeremiah, essentially on the legal regulation of access to justice data for legal tech innovation in the United Kingdom. We will be starting with an overview, let's say, of the scope of the work. Then we will come to our main argument, which is essentially looking at three combinations or constellations of the legal grounds that can be invoked to process data in this context. And finally, we will be coming to some limitations, let's say, of these very grounds and legal options for access to data by legal tech innovation. I think it's great for us that we followed up today from Jeremiah's and Abis's talks, because essentially we see how much important access to data, access to justice data is becoming as an issue in this context. It's really important for academics and for scientists, because we need to scrutinize digitalization of the justice system through better data and more comprehensive data. The idea of data access being patchy certainly imposes limitations on our critical ability, and that means that also limits our capacity to understand everything that is happening right now. Apart from that category, it's also really important for regulators and judges. I think Abby's mention was really spot on the concerns that can, let's say, arise when it comes to making access to data more widespread and perhaps indiscriminate. Finally, it's also really important for tech developers access to data. So in this paper, I think we are focusing on the latter category, and we are looking at access to data as a catalyst for legal innovation. And more specifically, when it comes to commercial entities, legal tech startups, and other entities interested in using justice data, accessing data that are held by the Ministry of Justice or the HMCTS or courts to produce cutting-edge legal analytics. Going back to John and Jeremiah's references, the idea, let's say, the normative appeal of this happening from a constitutional law perspective is the potential to have an important contribution to access to justice by essentially providing reliable and robust legal advice at the fraction of what specialized legal advice costs nowadays. So the question we sought out to answer here is that assuming that there are commercial entities interested in using justice data for this purpose, how compatible is this with our data protection law? And if it is compatible, what are the specific legal arrangements that entities should consider and the requirements they must satisfy in order to proceed with this? And how secure is this for data subject rights, and under which conditions should it be allowed? Now, one necessary clarification that we always have to do is that justice data, there are many different types of justice data, and I think by reading Natalie's report, everyone can see the different types of considerations here at play in the justice system. From judgments to metadata about how long the average case will take, to let's say administrative information about the process or the effectiveness of the process. There are different types of justice data. In our case, we wanted to focus on textual data. That means mainly, I would say, judgments as textual data. It could also be pleadings, it can be witness statements, but mostly judgments themselves as a whole, because we think there lies in the great potential to enhance access to justice. We should also, of course, not forget that there are some relevant, important policy developments lately. And I'm referring here to the National Archives, Ministry of Justice and Bailey agreement to build, let's say, a more comprehensive database of judgments in the United Kingdom. So we think it's an area where we're going to see important activity, and there is going to be commercial interest to access this type of data. So all the more the reason to consider the legality or the lawfulness of this happening. A second caveat I have to introduce here is the identifiability of the data sets. So it's certainly a context-specific question. It's not the case that data protection law will always be applicable if a commercial entity wants to access some type of justice data, some type of textual data in the justice system. And nonetheless, we have the impression through many conversations with people working in the legal tech sector that there will be the need to have some, at least, information that is considered personal information for a model to actually be able to predict the outcome of certain trial processes. The name of the judge, for example, or the name of the lawyer representing the parties is something that will be really difficult to eliminate from the data set, at least in the sense of complete anonymization. That makes it the case that we need to consider the GDPR and data protection law very carefully. And I have to say, when I say GDPR a couple of times in the presentation, I mean also the Data Protection Act 2018, which has transposed the GDPR into UK law now that we are in the post-Brexit world. Apart from the Data Protection Act, of course, there are also other layers, let's say, of other legal sources which are relevant here to this question. And in this paper, we think about how the Digital Economy Act can potentially enable this type of data sharing here. But also more importantly, and more, I would say, a bigger part of the focus is the potential constraints that we will have and the potential requirements deriving from human rights law. So this was, I think, in a nutshell, the question we sought out to resolve. And now I'm coming to, I would say, our answer to the question, which is that it's really important to tackle the question of where should the data controllers, in this case, the public bodies, rely on to disclose, to provide access to justice data to legal tech commercial entities. And this brings us to the first data protection principle enshrined in Article 6 of the GDPR, which includes all the potential lawful grounds for processing. And for present purposes, for our purposes, it's really important that we discuss two of them: the public interest and legitimate interests. The other potential grounds are not really applicable in our case. So when it comes to the public interest, we are talking about processing that is necessary for a task which is carried out in the public interest or in the exercise of official authority. And when it comes to legitimate interests, it has to do with the legitimate interests pursued by the data controller or the third party, unless those, let's say, override fundamental rights of the data subjects. Our analysis in this work concluded that here there is no, let's say, silver bullet or one size fits all. There are three alternatives we are kind of outlining and elaborating upon in the paper to determine how this type of data processing should happen and what would be the legal implications of it happening. So to us, there is a clear, the first constellation, which we call public interest processing, to us is a very clear demonstration of legal analytics serving the public good. So you can imagine here an activity like the Data First activity by the ADR UK, although in Data First we don't have commercial entities being involved, but I mean public data processed and analyzed only for the public good to gain more insights into how the justice system works. If, for example, a commercial entity participated in a consortium which gets access to MOJ data and cannot do any further processing or redetermine the purpose of processing, both entities could rely on the public interest, and that would make things quite clear. And essentially, the commercial entity would be a processor borrowing the public interest legal basis. Now I will quickly swap the order and go to the third one, which we call commercial processing, legitimate interest processing, in which case both the public body and the commercial entity could invoke legitimate interests. In that case, the public body would invoke the legitimate interests pursued by the third party to very transparently say that we are doing this to pursue the interests of the company. We feel that this is a solution that in theory is applicable, but it would be really difficult to enforce in practice, because we think both in legal terms, the balancing exercise would be really difficult to satisfy, because there is no contribution to access to justice. And the political aspect also would be quite tricky, we think, when it comes to providing access on that basis. So our, let's say, proposed or not proposed, but I think mostly discussed in this paper, potential constellation is the middle constellation you see on this slide, which is what we call hybrid processing. And this involves essentially a public-private data sharing collaboration, where the public body is relying on the public interest, and then the commercial entity can rely on both grounds. Initially, they also serve the public interest by producing some insights that will feed back into policy-making work and will improve our collective knowledge about the justice system. But pursuant to certain proportionality requirements, they are allowed to then repurpose the data to claim that they can further process it for to pursue other legitimate interests. But when it comes to providing some collective knowledge about the justice system, so things that are not for their own profit exclusively, this should be seen, in our view, as a contribution to the public interest. Now, to give you a conclusion of the analysis before passing on to Hannah, it's our argument that in principle, it should be possible for commercial entities to invoke the public interest as a lawful ground. But the reason we are actually discussing limitations and focusing also on legitimate interests in this paper is that regulatory guidance is very skeptical for commercial entities to invoke the public interest ground. This is also allowed in cases where you have a very tangible public service, like a public authority collaborating with a water company which provides water to an area. Data is not seen as water right now, but we don't really see the reason we should not think of data like water as long as certain conditions are satisfied, because it's the case that we can have important contributions to the public good. That being said, public interest washing is to be avoided at all costs, and this is a big challenge, a big governance, let's say, challenge for public bodies to meet when it comes to balancing this proportionate relationship between the public interest and legitimate interests. We can easily imagine, all of us, a tokenistic approach to saying we will produce a report for the Ministry of Justice when essentially this company wants to take the data to do something else for their own profit. So this brings us to the boundaries and limitations that must be observed when it comes to processing data in this context. And I pass over to Hannah.
Thanks, Sturgios. So as Sturgios noted, the rest of this presentation takes a closer look at the potential application of the legitimate interest ground to render this data processing lawful. Now, this focus arises from the potential difficulties that Sturgios identified that private entities can face when trying to demonstrate a public interest basis. Now, it's not that it is impossible. Prior to COVID-19, the ICO noted that some data processing by private water firms could rely on this ground. And during COVID, we saw private entities legitimize the processing of data for the purposes of contact tracing apps on this basis as well. These do suggest, however, that this bar is high. The focus on the nature of the function suggests it almost needs to be indispensable for private entities to claim this ground. And we're not quite sure whether perceptions of data use in this context are quite there yet. Now, we propose that the ground of legitimate interest may be a route for demonstrating the potential lawfulness of this use of data, drawing upon the ICO's legitimate interest assessment and existing case law. Now, we draw upon these materials to emphasize the continued applicability of existing principles as a means for facilitating appropriate reuses of data and their ongoing utility in guiding novel data processing activities and new partnerships forged between the government and commercial entities. Now, we see this as a strength in the law in this area, in its ability to strike a fine balance between providing certainty and guidance and enabling flexibility. So the ICO's legitimate interest assessment has 3 stages that we'll look at in turn, and data processing must demonstrate that it fulfills all 3 for this ground for processing to be applicable. Now, firstly, we need to determine if we have a legitimate interest. Regulators such as the ICO have acknowledged that this is a broad term. So whilst it precludes unethical and unlawful processing, next slide please, trivial, controversial, and commercial interests may nevertheless fall within its scope. This is echoed by the writing of the Article 29 Working Party. It highlighted that the notion of an interest was broader than a purpose. A purpose was understood as a specific aim, And whilst there is a need for some clarity, this interest could also be broadened to consider the benefits of the processing. You still need sufficient precision to be able to explain it, and these benefits must be real and correspond to your current or planned activities. But the relevant benefits here may accrue to data processors, controllers, data subjects, identified third parties, and wider public benefits. Now, we believe the data processing at the heart of this presentation could fall within the remit of a legitimate interest as required by the assessment. We can see collective benefits accruing through the ability of this processing to help remove or reduce barriers to access to justice, provide insights into the functioning of the justice system, as well as stimulating innovation and economic growth by supporting the growth of this sector. We also now need to determine if the processing is necessary. Now, this is a bar lower than essential, but it still must be shown that the processing here is proportionate and accurate. Now, such an assessment would be fact-driven, based upon the legitimate interest identified in the previous stage, and perhaps looking at some of the principles in Article 5 of the GDPR regarding data minimization. So whilst a definite yes or no answer cannot be given in this context, it's clear at the necessity stage that nothing inherently precludes this type of processing from taking place. Now, finally, we need to consider whether others' rights and interests are nevertheless sufficient to override the identified legitimate interest. And this is why the use of trivial or controversial legitimate interests may be possible, but are more difficult to rely upon as they're more prone to being overridden at this stage. Nevertheless, a negative impact on an individual does not automatically mean that the legitimate interest is overridden. The balancing stage requires us to consider the severity of the impact and if this impact is warranted in light of the identified legitimate interest. Now, in implying this balancing, we need to consider the nature of the data. Whether it's more sensitive or where it relates to vulnerable people, it's more likely that others' interests will override. But it's important to remember here that whilst many may think of justice data as purely concerned with this kind of sensitive data, that's not necessarily the case. That many insights can be drawn from patterns and correlations that do not rely upon individual sensitive data. We also need to consider the reasonable expectations of data subjects. Now, it's unlikely that many have considered this exact and specific secondary use of data, but if we broaden this out to consider the effective and efficient use of resources to help society, either through helping those accessing the justice system or encouraging innovation to stimulate economic growth, jobs, and general prosperity, I think we could see that there is a potential that that might be something expected by individuals. Furthermore, empirical evidence suggests that individuals already believe that their data is being used more than it actually is. Furthermore, we may see expectations develop to be more towards more open justice in light of some of the developments that we've discussed earlier, such as the increased publication of judgments and the increasing digitalization of the justice system. Now, finally, the use of safeguards and a consideration of the impact on individuals can help shift this balance. Here, according with the principles of data minimization and transparency, this may operate as safeguards to ensure appropriate uses of data. We can also reflect upon the lack of direct losses or disadvantages that might accrue to an individual here in terms of there's no risk of physical harm, no risk of financial loss accruing to individuals. Now, for the last slide, I just wanted to touch upon some of the case law that emphasizes what is required in this context. And these cases in front of the EU court emphasize that it is about this balance and that in defining a legitimate interest, there isn't a need to tightly prescribe every single aspect, and that it needn't turn into this mythical Herculean hunt for your legitimate interest. And so that is at the end of our presentation, and I think Rebecca and Tom are going to present theirs now.
Thank you very much, Hannah. So if I just share my screen. There we are. So hopefully you can see that now. So yes, in this section of the seminar, we're going to move. So the first two seminars in the series in the last couple of weeks have looked very much at tech for the practice and performance of law. You've seen through Abby, Jeremiah, Hannah and Sturgios very much the kind of absolute nexus of law and technology. And what we're doing in this section is moving sort of to the counter side, which is how we look at how law is going to have to adjust itself in order to take account of technology. So picking up on some of the developments we've just seen at the end of that one and looking at them in a different context as well. And this really is the coming challenge, which was one of the things that we in Work Package 5 of the overall project were looking to address, which is that even lawyers who are in conventional practice, so however conventional you think of your practice as being, however much you think of yourself as being a sort of normal lawyer, at some stage it seems very likely that even such lawyers are very likely to need to understand AI and other forms of technology and the impact that those technologies are going to have on the existing law. And one of the things that we've done in Work Package 5, which we'll talk to you more about in the next seminar next week, is to create a joint law and computer science course for students from both disciplines in which we look at some of these questions. And in the third section of that course, the one that runs through the spring term, Hilary term, we go through a different area of law each week, presented by people who are really just experts in that area of law, but examining how that particular area of that week will need to adapt its rules designed for humans in order to ensure that those rules still operate effectively and really well when they're applied to contexts involving technology. So just to give you a sample of some of the areas that we cover, we look, for example, at cryptocurrency and talk about that with some property lawyers. We look at algorithmic collusion, which we look at with my competition lawyer colleague from Pembroke, Ariel Izraki. We look at algorithmic discrimination and employment law in conjunction with Jeremiah, who you've heard from this afternoon. We look at algorithmic decision-making and public law. We look at concepts of privity and security and identity, picking up on some of the questions you've heard about just now. We look at another of my fields of interest, criminal liability, and the impact of digital evidence and the increasing prevalence of digital evidence in that context. So we look both at how substantive criminal law can respond to technology and also how the process and the evidence rules also need to respond to the impact of technology. And finally, we look at tort liability when the thing that the liability applies to is an autonomous system rather than human intervention. So all very standard areas of law, but with increasing challenges coming to them from the impact of technology. And what I'm going to do for the rest of this session is just to sort of give you as a kind of case study of that, a little bit of a deeper look into one of those areas, the one about algorithmic decision-making and public law. That's one of my areas of interest in research, and it'll sort of give you a flavour of the kind of things that we do across all these other different areas as well. The other reason I want to talk to you a little bit about that area in particular is because it's been an area where we've also been able to have some impact beyond the course during the course of the research project. So my co-convener of the Law and Computer Science course, Tom Mellom, and I have written a piece primarily aimed at practitioners on automated decision-making in the public sector. I've also written a more academic in-depth piece, which I think was circulated to some extent, which is due out any moment in the OJLS. We've also did a briefing paper for the Legal Education Foundation's response to the Law Commission consultation. So as you probably know, the Law Commission has been consulting on what it should look at doing for its 14th programme of law reform. And quite a few of us, including the Legal Education Foundation, have been saying, well, actually, algorithmic decision-making in public law would be a really good thing for the public law team to look at. And so in conjunction with Ruben Binns, with whom I co-teach on the course, and Lillian Edwards, we did a briefing paper for the Legal Education Foundation, and I know you're going to hear from Natalie later. In the same line, I also did a presentation for the Law Commission with the Socio-Legal Studies Association, and we've also done an event for the Civil Service Live again, looking on behalf of the GLD at this being something that GLD has been interested in, which we presented at the Civil Service Live event. And we'll also talk to you more next week about OLTEP, the Oxford Law Tech Education Programme. But again, one of the modules of that has also been developed in conjunction with various different partners. And one unit of that overall module involves this discussion of algorithmic decision making and public law. So for all of those reasons, we've had lots of engagement with people outside the project on this topic. So it also seemed for that reason like a good one to talk to you about. So if we have a think then about how algorithmic decision making is going to have an impact on what we understand as ordinary public law. And we all know that there are various grounds of administrative law. We know that public authorities have to follow fair procedures, that they have to have the jurisdiction to take a decision, they have to take into account the right considerations and only the right considerations, they mustn't fetter or give away their discretion to act, and their decision has to be reasonable or proportionate. And so the question is, well, does automated algorithmic decision making present new challenges given those premises? And the answer to that in some ways is no, right? Because humans are not perfect in their decision making either. There's lots of instances recorded of situations in which, you know, the distance the judges from their most recent meal will have an impact on their sentencing stringency, or the performance of a particular football team in America has been shown to have some impact on judges' decisions subsequent to that. So it's not like humans are perfect. And as we look at what ADM might do, it's important that we don't sort of hold it to an impossible standard that at the moment no human decision maker is reaching either. And we know that administrative errors and even the concept of an algorithm can apply in a very non-digital, very analog context as well. It might be that a decision maker has a sort of pathway that they have to follow. If this, then do this. Is the answer to this yes or no? If yes, then do this. So it's very possible that that kind of relatively rigid decision-making process can be in place. And we know that administrative errors or bugs can arise even in a very human decision-making process. So again, it's not like we never ever have any of these problems in the existing law as it is. So we shouldn't just assume that because a case involves ADM, it's inevitably going to raise lots of novel legal questions, and that's very much not the point that I'm making. However, having said that, there are some ways, I think, in which ADM does present new challenges for administrative law. And one of these relates to transparency. Now, the key thing here is to remember that automated systems can be simultaneously more, but also less transparent than the human equivalent. And we're very used to the idea that, yes, they can be less transparent. We know all about nonlinear systems and the use of machine learning and the fact that it can operate a bit as a black box and we might not know exactly why it's doing what it's doing. So that's a relatively familiar idea that the lack of transparency is something that might be new about ADM. What's perhaps not always realised is that such systems, or some systems, can also be more transparent. Because, for example, if you're dealing with a rules-based system rather than a machine learning system, there will be a lot more specificity of the rules that are laid down in the first place. Even if it is a machine learning system and it's not rules-based, we might be much more specific about the way that we're going to measure the accuracy of that system, or about the way in which it was trained if it was a trained system. And the labelling of the data that went into that system may be more transparent. Even the forms and mechanisms of how discrimination are going to arise in that system are probably more predictable and transparent than they are in relation to human decision makers. So in some ways, actually, we will know more in a way about the way that these systems are operating, and there will be more kind of open decision making in advance of them running. And what I think of that as doing is effectively giving us, if you like, a kind of greater surface area of potential issues to arise on which administrative law can then bite. So a potential greater surface area for those legal issues to arise. Another way in which ADM may potentially present new challenges relates to that issue of the metrics of accuracy that I just mentioned. And we know that a number of different metrics can be used to assess a particular system. So we might say, okay, how many of the target instances it was set up to detect did it detect? We might want to say how many of the positive results it generated were actually positive results. We might want to say how many of its negative results were really negatives, or how many times out of the whole sample did it correctly classify a result either as positive or as negative as appropriate. And again, this is not unique to ADM. If you're thinking to yourself, well, that sounds horribly familiar, it is, I'm afraid, very familiar to all of us at the moment, because we think a lot about the relative performance of different COVID-19 tests that are available to us at present. So again, not that this is a brand new challenge, but the idea that the law will actually have to rule on some of these things may well be a new challenge for administrative law, and it may well have to do that in the context of ADM. And this question of whether which metric makes a system or a deployment of a system, for example, reasonable within administrative law, is not really one that public law has yet had to grapple with. We see a little bit of it in the Bridges case. So this is the case about South Wales Police's use of automated facial recognition technology. And one of the things the court said was problematic, and one of the reasons why it breached the public sector equality duty, was they hadn't retained the documentation of faces that were detected but then rejected. So in other words, they hadn't kept track of their negative results. So therefore, they couldn't work out what their false negative rate was. Now, they'd done that for perfectly good GDPR reasons. They were trying not to retain more data than they needed to. But in fact, they did need to retain that data, because without it, they couldn't check their false negative rate. And that was something which would then potentially be discriminatory and potentially problematic. So we see in that case the very start, I think, of what is going to be a growing issue for courts, as they have to work out, well, which metrics were deployed to test a system, and were those the right metrics, and was deployment of that system reasonable, or were the outcomes produced by that system acceptable within public law given the use of those metrics. Another way in which these systems may also present new challenges is that we know that they focus on correlation as opposed to causation. So we tend to think of human decision making as being causal, whereas it's in fact wrong to even think of them as making decisions, because what they're really doing is making statistical predictions based on correlation. So machine learning, we know, relies on these statistical inferences, not reasoning of a kind that a human does. So if a system uses that approach, to what extent is that mere correlation going to be sufficient to justify the use of the factor in making a prediction or a determination on a particular case, if it's a correlative feature rather than a causative one? What if a system, for example, makes decisions on the basis of a feature which correlates very well with a particular outcome, but we can't particularly see a causal relationship there? Would such a feature be a relevant consideration? And you might be wondering, why in the world is there a picture of HP Source on that slide? And the answer is because there was research done after the Brexit decision, which established that if you were likely to buy HP Source, if you looked at your weekly shopping basket, if it contained HP Source, that was very strongly predictive of the fact that you would have voted for Leave in the referendum. Now, I can't obviously imagine a world in which it would be legal to try to detect whether that was the case or not, or base a public law decision on it. But let's just assume for a moment that it was. If that was a very, very correlative feature, something which could outperform a human being, detect the sample group much more effectively than a human being would, and yet seems totally unrelated to it, would that make it, for example, a relevant consideration which it is lawful to take into account? Or would we say, no, because it's not causal, it's an irrelevant consideration which must not therefore be taken into account? Not something the courts have had to grapple with yet, but you can see it's something that they might have to grapple with in the future. So the good news, however, is that although there are these challenges out there, and there are ways in which admin law is going to have to develop and think more carefully about this technology to come up with answers that it doesn't currently have, there are very clear ways in which actually public law is already very well set up to help here as we look at algorithmic decision making. So, for example, GDPR Articles 13 to 15 say that, among other things, the data subject has the right to meaningful information about the logic involved in automated decision-making. And we know that the meaning of that phrase has been the subject of very lively academic debate. There was a sort of an initial relatively cautious approach by Goodman and Flaxman, approach from Werchter and Mittelstadt, which said that actually probably it didn't require quite as much as originally thought, and then a more contextual approach from various other people since. So we know that there's been a debate about what does this mean? What is meaningful information about the logic involved? Well, actually, at common law, the duty to give notice is something that's already really well established. Even in closed material proceedings, we know that the defendant has to be told what's called the gist of the case against him or her. And in Borgas, Lord Reed said that a prisoner's right to make representations is largely valueless unless he knows the substance of the case being advanced. That won't normally require the disclosure of the primary evidence, but it will require genuine and meaningful disclosure of the reasons why the decision was made. And general statements about behaviour or risk and so on were held not to be sufficient. So actually, it seems likely that that common law understanding might be very useful in informing our debate going forwards about what actually does meaningful information about the logic involved means. It certainly fits very well with sort of where we've got to in that academic debate. And it also fits quite well with the ICO guidance, which says, well, really, it's about what a person needs to know in order to be able to assess whether they think the reasoning of the decision is flawed and challenge it if so. That very much echoes what was talked about in gisting in the Borgas case. So it may well be that actually admin law has a source of learning on this already that we can bring in and use in this context. And there are other examples, that's not the only one. So for example, the GDPR also refers to the concept of proportionality quite regularly. You were hearing about that just now from Hannah and Sturgios. And we're told, for example, that processing of Article 9 sensitive data has to be proportionate. Well, again, admin law has a wealth of case law already on what we mean by the meaning and applicability of proportionality. So again, it's a resource that's really there already to be used. We also might worry that there might be over-reliance on automated decision systems or potentially over-rigidity of decision-making if it's done by a machine as opposed to what we think of as a sort of more flexible human. Well, again, admin law already contains rules on fettering and non-delegation to deal with that. So again, there is already case law out there which discusses that being a problem in the decision-making context and thinks about how we might do better. And that again is really ready to be used and help in the context of ADM. And actually, I think there's a separate question whether if we do develop these grounds properly, they could in fact provide us with some techniques that we might even start to think about using outside of public law. One of the key determinants of the application of public law is the imbalance of power between the decision maker and the private individual. But if we think about it, that actually applies more generally to the use of ADM, wherever it's used, even if it's used by a private decision maker, not a public one. And we know that public law is leaking outside its traditional boundaries anyway, in some cases like Braganza, which employed the Wednesbury concept in an employment context. So what we have is we have an area of law specifically set up to optimize and make as fair as possible the decision-making process. Seems to me that might be a useful resource that we might want to use even outside the public law sphere, even in private law. But sort of final note of warning to sort of end on, if we're going to do this, lawyers and computer scientists are going to have to work very closely together to understand what the different standards are that might be applied and to set those standards. So for example, in choosing a particular form of ADM for a particular context, or in choosing the metrics which are going to be used to assess the performance of that system in a particular context. That is something where the lawyers are going to need to understand enough about the technology to be able to work out what the law should do, and technologists are going to need to work with the lawyers to ensure that the technology matches the context as well as it possibly can do. And that's something which is going to need to happen, both as those systems are designed and deployed in the first place, but also down the line when their deployment or the decisions that they make are reviewed in court through judicial review, for example. So we can meet these challenges, and I think the area of law provides a really exciting opportunity for us to meet them, but it's not something that either discipline can do alone. What we need to do that is a fully interdisciplinary approach. And that, as I say, is something we've been working on in the course and something that I will talk to you more about in the next seminar, but that's all for me from now.
Thank you so much to the presenters of those research projects. And now we're going to turn to the panel discussion. As we're doing this, please keep the questions coming in. You can put questions into the Q&A and then we will get the chance to discuss these at the end of the panel discussion. So our first panelist is Sir Ernest Ryder.
John, thank you very much, and to each of the discussants this afternoon. Can I start off with the first paper from Jeremias and Abby, which developed a question of fundamental importance to the delivery of justice, reform of justice systems, and of course, AI. Access to justice is a principle less likely than many think to be available in English and, for that matter, Scottish administrative law, where the individual claimant seeks to vindicate a meritorious claim. And so being able to challenge the overall design of a policy scheme is critical. So systematic unfairness as described and the tests to be applied are, I think, key. For those of us who lived the employment tribunal experience, in my case as their ultimate head of jurisdiction, where we had to explain to government and to select committees in Parliament why the fee regime was wrong. The decision in unison and the analysis by Jeremiah and Abby was of very great importance indeed. They rightly, if I may say so, in their paper summarized today and identified a futility framework that is not a counsel of perfection. The Zuckerman trade-offs, if I can call them that, are important, and the example is well known to me. The digitization of tribunal process has involved very different balancing acts between and in each jurisdiction. So, for example, immigration is very different in its end-to-end software development from something that one applies to special educational need and disability, or for that matter, benefits appeals. And for a justice system to be developed, planned, improved, or neutrally just changed, for example, during a pandemic, there must be a framework within which to analyze cost-benefit questions, which has a principled structure or context. And that's what the proposed tests for structural unfairness do for me. They put into coherent and perhaps formulaic form the value judgments that policymakers, including rules committees and those who run the justice system, chief justices and their political colleagues, must be aware of. And that, of course, is what some of those people might most likely object to, or at least be apprehensive about. The identification of legal rules as criteria by which politicians, qua government, and leadership judges who are responsible for the delivery of justice can be challenged with may lead on their part to defensive, conservative responses. But that doesn't make the rules any less necessary, if anything, rather more. And when Jeremiah and Abby first mooted the project that led to this paper, I exclaimed in some overexcitement that they discovered one of the essential components for the study of the delivery of justice. And I remain of that view. Let me just expound for a brief moment on, of course, what the risk of developing this concept is. Perhaps the person most well known for exposing the risk is Lord Sumption, who extrajudicially has cautioned us about the perceived political role of the courts. That is, the courts, he says, no longer consistently distinguish between cases where a minister has no power to act or to act for that particular purpose, and cases where the judge, and note the language, the judge does not like the underlying policy. Put to one side that I don't think that that fairly reflects the overall argument, but that is the risk that we need to meet. And I think the principles described by Jeremiah and Abby will not only answer that point, in other words, that systematic unfairness is politics by another means, but it provides a coherent and incrementally developed basis in common law with tests that can be rigorously applied both by first instance judges in the individual case looking at the fairness of policy, but also judicial leaders running justice systems. And of course, the significance of this for chief justices who might want to be defensive of their own statutory duties in the administration of justice is fairly obvious. But the basis that it provides for the consideration of new ways of working, the use of AI by judges, representatives, and citizens, and digital reform generally are quite profound. And so I accept that Jeremiah and Abby have described a conceptual framework, a standard of scrutiny, and an appropriate threshold for illegality challenges to policy. I think the outcomes should not be regarded as political activity by another name, but a procedural proportionality, which provides a link between the value of the right in question and the process required. And that is something that judges and the executive should alike welcome. It reflects the statutory duties placed on judges and the executive, who are charged with developing policy, and that has significant access to justice implications. And so the start point for today is one that I profoundly welcome and would love to see much more development of the detailed thinking that comes out of it. So then can I turn to the second presentation by Abby on online judgments? And for me, this is of equal importance because open justice is, of course, another fundamental principle. And it is in its operation the means by which we maintain political liberty and the rule of law. So we've debated one component of that, and that's the equality of access in response to systematic unfairness. And we can, I suspect, readily acknowledge the problems created by dispute resolution that is private, whether that's private commercial or private by the absence of appropriate open justice in the public arena. And so a very interesting question for me again arises. Are the consequences of open justice in a digital environment capable of being regulated to ensure that claims are being adjudicated fairly, effectively and efficiently, without the risks that our colleagues here identify from the harvesting of data from the judgment database, or indeed any other public materials associated with that database? And again, for me, the experience of the employment tribunal is important. I mean, there we have a jurisdiction that has volume considerations and also some complex adjudications, which contain both lay and professional judicial components. So there are all sorts of interesting things behind the scenes going on with drafts of judgments prepared by different people leading to the eventual product that you see. There is, interestingly, a problem touched upon by Abby, which is whether we know that the basis for publication of all of the employment tribunal judgments is sound. I mean, is it a coherent system, or as coherent as we think it should be? And that's another interesting question for further empirical testing. And there are other things that are not quite yet right, which we could comment on. For example, the publication of the database is an issue in itself. Judicial judgments are not part of gov.uk and shouldn't be. And despite 3 years of representations on that point, they're still published under that banner. But of course, it's much more important than that. We're looking at content here, and the content of those judgments provides both an opportunity and a threat. The Information Commissioner, for example, has for some time been interested in that content. Would that the public knew what has been said to employment judges and their leadership judges about how judgments should be changed. But that is the debate that has already been in being for some while. And whether it's simple questions like the identification of the judge and members, representatives and witnesses and parties, or much more worrying questions arising out of deeper harvesting and analysis. One thing is clear to me, at least from the history that I've seen, that is that judicial responses to those possibilities, or all highlighted in the paper here, have to date been defensive. And some might argue perhaps even defensive and superficial. It looks as if the judiciary has been concerned more with the threat of forum shopping by the publication of judgments than with other threats, very, very practical and important threats, and also opportunities that one gets from qualitative analysis, which are not just limited to predictive outcomes in relation to the particular judge. And perhaps they've also been rather over-concerned with another simplistic analysis, and that's based in the concept of judicial independence, which has been used as a defensive catch-all for not doing anything, whereas one should be looking at the detail of protections against blacklisting and other practical problems that Abby and Jeremiah have highlighted in the paper. And it may be that greater regulatory control, in other words, using existing safeguards, including anonymization, would produce a better understanding and a better end product by the judiciary, so that there are better safeguards in the use of the judgment database that already exists. But I rather think that's unlikely to be enough. What I would like to suggest is that the use of the futility framework and its tests was key to the judicial function of affording access to justice as part of a leadership function, and in exactly the same way, the development of better safeguards in relation to the use of data arising out of open justice considerations is just as fundamental to the judicial function. And so I welcome again the opportunity to look at systemic answers. And I think, for example, looking at what some specialist fields of adjudication and court jurisdictions already do in respect of anonymity is not a bad start, because there are some good practice examples there. I mean, for heaven's sake, it took us over a decade to get family judges to start to anonymize judgments even remotely well. And it becomes eventually just an ordinary process of writing, and nobody thinks twice about it. You don't identify a child by their date of birth. You don't allow for jigsaw identification in the way you piece together an essential story in order to identify what it is as a problem that you're going to try and help solve. And so there's already quite an element of good practice we can build on there. We can use confidential schedules so that what is anonymous is in fact backed by the real material that tells you precisely who has defaulted. And that's very important if it's a local or central government agency that regularly defaults. And if you're not identifying why there's been a default by identifying them because of anonymity considerations, you might be missing a real trick. Classic example might be, for example, the failure to engage with UCAS of many central and local government agencies, thereby putting the employee in a position in an employment tribunal which is relatively unfair. You need the data in order to bring out that hypothesis into the public domain. And so I think there are good examples that we can build on. I think there's a lot that needs to be done by way of the development of safeguards using academic research and empirical demonstration, but also there's a training component. I think there's a real training obligation here to help the judiciary understand what is a quality judgment. There are some really good European examples which are absolutely in compliance with GDPR and don't take away any of the content and force of the reasoning and the end conclusion. And we can address the broad Article 8 issues by these training exercises. And so what is a good judgment and how do you publish are things that I think heads of jurisdiction and judicial college leaders should be very alive to. And they should be alive to them now, not in a decade's time, because it's now that AI and digital reform really are beginning to hit individual judges and therefore their litigants and representatives. So instead of worrying about how to restrict the use of data, I think the system's response should be to lead by example and good practice, and the opportunity should be taken to develop principles in relation to the ethical use of AI to enhance open justice, just in the same way that the principle of utility can be developed in relation to access to justice. If I go back to a lecture I gave as long ago as 2018 to the Max Planck Institute on open justice, I identified some principles that might help us develop along this line. And eventually I ended up with a rather simple common law example, which it seems to me for students of law is always a good place to start. If you take the Huang principle set out by Lord Bingham, you might actually be able to develop the very open justice principles that Abby and Jeremias have flagged for you in the paper. So just to give you the 4 components there, we need a policy objective that furthers open justice. So where is that from government and judicial leaders? We need implementation measures that are designed to implement that objective and which are rationally connected to it. The measures must be no more than is necessary to accomplish the objective, and they must strike a fair balance between the rights of the individual and the interests of the community. So that's the next challenge. But I think what we've got here from our discussants is a fabulous start point to a really interesting debate about AI and digital reform generally. And thank you very much for that.
Ernest, thank you for that fantastic opening presentation for the panel discussion. We'll now turn to our second panelist, Dr. Natalie Byram.
Thank you so much, John, and thank you for inviting me to speak on the panel today. It's always an impossible act to follow Sir Ernest, but I will do my best. So, as John mentioned in the introduction, my name is Dr. Natalie Byram, and I'm Director of Justice Lab, a new initiative developed by the Legal Education Foundation. One of Justice Lab's key objectives is to improve the quality and accessibility of data about the justice system, to support research, to promote accountability, and to develop new solutions to access to justice challenges. Between 2018 and 2020, I was seconded to Her Majesty's Courts and Tribunals Service as expert advisor on open data, with a remit to advise on data collection, sharing, and governance. I currently sit on the Shadow Senior Data Governance Panel, the newly created body tasked with taking decisions in relation to applications for data access that may be considered novel or contentious. I want to say first, I'm really grateful to John, to Abby, to Jeremias, to Hannah, Sturgios, and Rebecca for the thought leadership they've provided through this project, and for surfacing some of the most pressing issues the justice system in England and Wales and justice systems globally face as we transition from local, paper-based processes to a centralised, digitised system. Listening to today's presentations, it's clear that the issues are many and various. Just thinking about some of the questions raised include, how do we balance the right to privacy with the vital requirements of open justice? What values and whose interests should we privilege in providing access to data? How do we identify threats and opportunities that are real and material and differentiate those from those that are theoretical and illusory? How can we meaningfully address risks, as Ernest said, through regulating data access or through regulating data use? And how can we devise arrangements for data access that uphold rule of law principles around equality and promote the effective administration of and access to the justice system through the use of data? In the 10 minutes or so I have with you today, I want to reflect on the presentations we've heard, the broader value of the work of this project as a whole, and share 3 thoughts and reflections about where we might need to go next if we're serious about creating a mature, trusted ecosystem that enables us to harness the undoubted benefits that better access to data can offer. So firstly, I think one of the really valuable contributions that's been made by this work is to expose the foundational gaps in our understanding of the legal status of data and information generated by the justice system, and therefore the applicability of potential gateways for facilitating broader access. Questions that we don't have answers to include, but are not limited to, things like who owns expert reports that are submitted to the court? Who controls data generated by the justice system? Is it HMCTS, is it MOJ, or is it the judiciary? Are published judgments subject to rules around the reuse of public sector information? These questions, it has to be said, are further complicated by the extent to which responsibility for storing and publishing data has been delegated to private actors, and a lack of transparency regarding the contractual arrangements that are in place to facilitate this at present. Legally, many of the answers to these questions are unclear, and arriving at a good answer will require negotiation between various actors and interests. It's for this reason that the Senior Data Governance Panel has been set up to facilitate a dialogue between the Judiciary, the Ministry of Justice, HMCTS and civil society, and particularly those organisations who support and represent the interests of users of the justice system. Formalising this body, placing it on a statutory footing and creating a public appointments process for members is a vital next step in ensuring confidence. In terms of a guiding principle for data sharing, I think health provides an important comparator. Health data sharing in the absence of patient consent is only permissible if the sharing will promote public health. In relation to justice data sharing, it follows that decisions on data sharing should be taken in the interests of promoting the effective administration of and equal access to the justice system, which can be found in the court service's public task. So secondly, moving beyond questions of legal status, experience from health has taught us that clear legal gateways are necessary but insufficient to create an effective data sharing ecosystem that commands public trust and confidence. Care.data and the recent GDPR scandal clearly demonstrate the risks of moving beyond public acceptability. Initiatives fail and are shut down, and researchers, commercial actors, and the public all lose when public's views aren't taken into account. In justice, we simply do not know what the public, or indeed those who use the justice system, think or feel about data sharing, particularly in relation to commercial access. There's an urgent need for research and public consultation to explore public attitudes, with a particular focus on understanding the experience and views of those who are already marginalised or lack trust in the justice system. Justice Lab and other foundations stand ready to fund and commission this work, but for it to be truly effective, the process and the findings need to be baked into decision-making processes and structures. Public acceptability is not and should not be considered a nice to have, and government mustn't consider it such. So thirdly, and in closing, much has been made of the potential for commercial access to justice data to improve access to justice. The government has invested millions of pounds in recent years in pump priming the nascent law tech sector, with very little to show for it in terms of outcomes. Experience tells us that investment and improving data access are of themselves insufficient to ensure that products and services that truly address access to justice challenges will be developed. A recent paper by Burhain et al., exploring the values encoded in machine learning research, found that in spite of the vast sums of money that have been spent on supporting projects testing the application of machine learning, societal needs are, and I quote, very loosely connected to the choice of project, and consideration of negative consequences is extremely rare. We need more empirical research to independently evaluate the use cases for justice data and to test the efficacy of products that are being built. More needs to be done to incentivize research that uses new data to enhance access to justice and contributes to equalizing inequalities of arms. Funders in supporting this research must ensure that users' voices, priorities, and experiences are heard in the development of new products. Only then will improved access to justice data deliver on its promise of improving access to justice. Thank you very much.
Thanks so much, Natalie. And I'm going to hand over now to our third panelist, Professor David Engstrom.
Thanks, John. Good morning, all. Emphasis on morning, as it's a little after 7:30 a.m. for me here in California. So please forgive me if I seem a bit bleary-eyed. I want to start on a note of admiration, which is that I had the great pleasure of spending several days in Oxford, actually just before COVID hit. It was literally, I think, a week before the first shutdowns here in the US. And I sat in on classes, indeed one of the classes that Becca described earlier. And I talked to lots of people. And I've been following the project ever since. And I have just been so impressed by and even envious of how much the project has accomplished, both pedagogically and substantively. And I guess I say that as someone who comes from Stanford University, which of course is a place that thinks it knows a thing or two about technology. So let me turn to the paper and the presentation. As you already heard it steps through the ways that the mix of statutes and doctrines that make up UK administrative law can bring some meaningful accountability to growing administrative agency use of various algorithmic tools of governance. And that's a super important issue right now for many reasons that Becca and Tom in the paper, I thought, really well articulated. Algorithmic tools, they're opaque relative to many analog tools. Relatedly, their more advanced versions, at least, cannot by their very structure engage in the sorts of reason giving, the giving of explanations that helps legitimate all of administrative government. And of course, the tools are often worryingly brittle in their outputs and in their predictions. But I think the issue is particularly important because all of the rapid increases in analytics and data quantity and compute power that's represented by AI, together those things mean that these algorithmic governance tools can do a lot more than automated governance tools could do in the public sector previously. And indeed, we can think of these tools as moving very quickly to the center of the coercive and the distributive power of the state. And so in some of my own work here in the US, I've shown how AI-based tools, mostly machine learning tools, are being developed and used, for instance, to choose regulatory targets at some really big and important agencies like the Securities and Exchange Commission or the Internal Revenue Service, that's our tax authority, and the Environmental Protection Agency. And tools are also being used to distribute social welfare benefits. So think disability benefits at the Social Security Administration. And so that's right at the center of the most important work of the state. And that's what makes this round of innovation different from past rounds. So from there, I want to use as a jumping off point 2 points that Becca made in the presentation and that Becca and Tom made in the paper, to do some wider thinking about where I think work like theirs can go from here. And the first of their points was that ADM can be both less and more transparent than analog systems. And the second point that I made that I want to use as that jumping off point is that there might be some good news here amidst all the hand-wringing that we're doing about the black box of AI and the awesome power of this newly automated state. And so I guess I'll take those 2 points and I'll add on top of them just 3 ideas that I always seem to come back to again and again whenever I think about how all of this is going to play out in the US. And so maybe this is just remaking or repackaging some of Becca's and Tom's points with the US gloss. Maybe it's a kind of a yes and from across the pond, but here they are. One is a descriptive point, and it provides, I think, a note of realism about where the legal solutions here are going to come from. So that's the first point I'll make. A second is an empirical point, which is about how AI is going to change public bureaucracies. And then the third is a legal and more normative point about the role that law can or should play. And it kind of builds off the first two. Okay, so here's the first point. It's the realism point. And it's that in the US, and I think in the UK too, but I'm not sure, we're not going to really get legislation on this, certainly not in the public sector. And instead, algorithmic accountability is something that's going to be litigated under existing administrative law doctrines. And so put really succinctly, algorithmic accountability is going to be litigated, not legislated. We're not going to get bespoke new rules that govern how agencies deploy these tools. And that means that administrative law is going to be a kind of grand experiment. And as Becca noted, in a variety of ways, administrative law is already kind of an ideal sandbox for thinking about algorithmic accountability, but it's also going to be throughout very much a second best adaptation. I think that's super important to keep in mind. That's a note of realism. Here's the empirical point. It's a little bit longer. I think one of the absolutely critical questions when we think about public sector use of AI is how AI is actually going to change bureaucracies. And interestingly, you can think of bureaucracies as already being a form of AI, right? Any bureaucracy, any big organization is just a set of structures and processes and decision-making nodes, and we diffuse a bunch of inputs through it, and out the back come a bunch of outputs. And so when I think about this, I think the really interesting empirical question that's going to hang over all law reform efforts in this area is what happens when you add AI to something that already is, in a sense, AI? Now, one possibility, as Becca noted, is that we're going to end up with less discretion, and AI will surely kill some discretion. It'll destroy some of it, and you know, legal people who work at the level of legal theory and jurisprudence, they say that AI is going to bring about a broad-scale shift from standards to rules. Right? On this view, standards are just a response to a lack of precision in crafting and implementing rules that can map to our normative purposes or ends. And AI is going to change all that maybe overall by moving us more in a rule-like direction. We won't need standards anymore if we can formalize things in the form of rules. But my view is that that's hardly the whole story. And indeed, AI can't destroy discretion entirely, and more likely it's just going to shift it around. And the way I like to think about it, and this maybe just restates Becca and Tom, is that AI is going to shift discretion in three ways. It's going to shift it up, over, and out within public bureaucracies. It's going to shift it up from the line level, from the street level bureaucrats who do a lot of the real work that agencies do, up to their managers. It's also going to shift discretion over from all of those denizens of agencies who do a lot of the work now, the lawyers, the economists, the political appointees. It's going to shift discretion from them over to technologists. And then finally, it's going to shift it out. It's going to shift it out from public bureaucracies to the private sector via the procurement process. From there, I think the really interesting question is, like, what will the net effects be? Right? We're likely going to get better managerial control in that shifting of discretion up, which we might think is good if what we're worried about is horizontal equity or arbitrariness in agency decisions. But we're obviously going to lose a certain amount of control, and in particular, public control over how discretion is exercised. And that's all one big empirical question. What's going to be the net effect of that up, over, and out? And I think that's the kind of work that we need to do to really roll up our sleeves and get inside organizational contexts and understand what those net effects are. And I would think that Becca and Tom and others who are working on this project are really ideally positioned to start doing some of that kind of work. Okay, here's the third and final point. It's kind of the legal and the normative and even the creative one. And the basic question, of course, is how can and should law be deployed then to constrain agency use of AI? And in particular, to try to shape that shift of discretion that's going to happen in good and welfare increasing ways. And I think there are lots of ways to answer that question, but I'll just touch on one. And I think it connects directly to Becca and Tom's notion that there may be some good news here, and that it's possible to use law in ways that leave us better off, or at least not worse off as a transparency matter. So here's what I'm getting at with that. The example I think is a really good one. It's enforcement tools that I already mentioned that many US agencies, from the IRS to the EPA, the Environmental Protection Agency, are developing and in many instances already using to choose regulatory targets. But there's a real challenge here when we think about how we're going to try to constrain that exercise of discretion through, especially when it's exercised through algorithmic tools of various kinds, which is that in the US, we already hive off agency enforcement decisions from judicial review. We have a reviewability doctrine that says that those agency decisions are generally not reviewable by courts under principles of administrative law. And there are a bunch of reasons why we do that. We do it because we worry we can't reconstruct any particular enforcement decision when it's made by a bunch of far-flung prosecutors or line-level enforcers within an agency. We're also wary of judges who have a very limited view inside an agency. We worry about them second guessing agency policy priorities, especially because those policy priorities are often based on the fact that all agencies have scarce budget. They have infinite things they could be doing and finite budget with which to do it. The point is that enforcement is already a black box in American administrative law as to, at least from the perspective of judicial review. Here's what I find really interesting. As agencies digitize, as they use more and more automated tools to do their work, it's possible that we will counterintuitively actually get more transparency over agency action, more transparency than we had in that analog world over those dispersed prosecutors or those dispersed line level enforcers. And indeed, those agency enforcement decisions might become far more tractable and cause us to rethink the doctrine. We might think there's enough of a hook, therefore, to actually do judicial review of agency decisions. Your own countryman or country person, Richard Susskind, he has the new book, Online Courts, and he has a really lovely framing of this. And it's really stuck with me. And I know it's more drawn from the courts and adjudication side of things than the kind of public sector AI administrative law side of things. But he says that in our pre-AI world, we had really high decision level transparency, but low system level transparency. And so I guess, one way of thinking of my suggestion here is that AI plus all the broader digitization that is part of, AI may, across lots of different organizational contexts, actually flip that state of affairs. Or indeed, it might even boost both. It could ultimately boost both decision level and system level transparency. And so to my mind, the challenge for law is how we can capture some of those gains and produce some of this good news that Becca and Tom are talking about. It's not obvious we can do it. There's plenty of peril, and I think Becca left off on a nice pessimistic note in that regard. But I guess that's one way of thinking about how we could get to some of that good news. So I'll leave off there. Thank you so much for having me.
Thank you, David, and thanks again to all the panelists for those super comments. And there's an awful lot of food for thought and discussion. I noticed we've got a good number of questions coming through, and I'd like us to move now to having a discussion around some of these. And one of the questions comes from Rickard Kemp, who asks, would it be possible to share some thought on the application of synthetic data in law during the session today? So I guess the vision or the promise here is that synthetic data might be a way to get around the challenges of privacy, because with synthetic data, we're not actually using anybody's personal data. But there's a technical question as to, well, how useful can synthetic data be? And in fact, can we generate useful synthetic data without processing real personal data? So I want to put these questions to Professor Tom Melham, who's in the Computer Science Department at Oxford.
Thanks, John. Yes, so interesting question, and anyone who's encountered a very interesting sort of AI gadget that we have these days called a generative adversarial network will see some fascinating examples of synthetic data where a GAN, generative adversarial network GAN, can create facial images, pictures of faces of people who never existed, and extremely realistic looking images of people who never existed. Or we're using GANs to create other realistic data. But all of those types of things, and I'm not only talking about GANs, but basically anything. What you need to think about when you think technically about this is the data set as a whole, right? So what we want is a data set as a whole, which is a replacement for a data set containing personal information. It's not about the individuals in the data set so much as the use of it is having a data set as a whole. And the key property you need of such a data set is that it's got a good statistical correlation with the distribution of cases in the real world or in the application domain, right? So if you're training, for example, a piece of statistical AI, you need to use a data set that's got data in it that are representative of the distribution or the spread of cases that you will encounter in its application. And of course, if its application is to real people, then you need some way of ensuring that your synthetic data is representative of the statistical distribution of data about real people. And I don't see a very easy way of getting around the fact that you'll have to look at individual people's data or data from individual people in order to get that kind of characteristic. Now, there's a little bit of a balance here between what you need to achieve like this training of an AI and the sort of features that the system will be looking at. So it may be possible, for example, to take a statistical summary of real data as a sort of firewall between the private data and some system that's being developed in ignorance of the private data. And if that statistical summary is sufficiently opaque and doesn't reveal any individual person's information, and is sufficient for generating or building the system you want to build, then that might be a way in which you can apply some insulation between the private data and the developer. But really, if you're developing a statistical AI system that's meant to be used in the real world on cases that come from individuals, you're going to have to develop. You're going to have to make your synthetic data from a representative sample of real individuals ultimately, and so that's something we just have to cope with. I think, at least for now, technically. I hope that helps.
Thanks, Tom. That's a really useful insight. I want now to pick up on a question that Tracy Vigro from the SRA has put in the chat. This is a great question. What's the one thing you think regulators should do to help demystify the perceived threats or risks? And this question, I'm just going to see who would like to respond to this question amongst our speakers and panelists. I'm sure there may be a variety of different thoughts on this. Does anyone want to go first?
I don't mind coming in, John.
Thanks,
I think actually, I think it's really interesting. The other limbs of your project, I think, have given us some really useful ideas for the role that regulators might take up in this space. I think one of the things about demystifying the risks is this lack of really an empirical base for getting to risks that are real versus ones that are theoretical. And so I think that this is, how do you regulate a product when you're not yet sure whether it's of any use? And I think one of the things that's been of concern to us and some of the organizations that we fund is that there's been this real sort of buzz around law tech, which is great, but I just don't feel that we've been asking those who produce these products hard enough questions about whether or not these tools can actually deliver on their promise to improve access to justice. And so I think there's definitely things that regulators can do around improving transparency about the data that these companies are using in order to produce their tools, and other things in supporting more foundational work to look at things like what are the higher and lower risk applications of tools like natural language processing when applied to judgments. I think it's a longer conversation, but I'm really pleased that a regulator's been in the room, and I encourage you to look at the rest of the project's work on this.
Thank you, Natalie. Does anyone else want to jump in on this, or shall I'll move to one of the other questions? We've got quite a few in the queue. And Oliver Butler has asked two GDPR related questions. So Oliver asks, how easy is it to satisfy Article 6.3 GDPR for public interest processing in this area? And to what extent is there a risk that drawing learning from administrative law in England and Wales when interpreting the UK GDPR will lead to divergence from the interpretation of the GDPR in the EU, and is that problematic? Sturgios, you indicated you'd like to respond to at least one of these. Can I ask you to jump in at this point?
Yeah. I will take the first one. So Oliver, I think it's a great question. It's really so interesting because we will probably end up with different legal frameworks here on the UK and on the EU level, because on the one hand you have obviously the UK, the 2015 regulations, the RPSI, and on the other hand, you're going to have the European Data Governance Act when it becomes a regulation. It is my understanding that the European Act is going to be a bit more modernized for the purposes of actually reusing data for the type of use we presented on today. So it is one of the big aspirations to allow actually SMEs and companies to reuse public sector data for purposes like access to justice and many other things, of course. The RPSI regulations, I think it's a bit more like the Freedom of Information Act in terms of its structure and how it envisages what is a document in the public sector and what is information. So perhaps a bit more static and different in scope. But there are also other questions that one has to ask, like, is this type of data analysis something that can be considered research? We do discuss this in the paper, and the short answer is that in most cases, no. But it's a matter that really, I think, deserves close legal attention and analysis. And perhaps, we could even join forces and write a paper on that. I think it's really a great question that you raise in terms of the domestic legal basis.
Thank you. Becca, did you want to comment on the other one?
Yes, please. So just to say that, because we should remember that English administrative law itself is not just purely domestic and has some of its origins in either EU or in particular ECHR law. So for example, the gisting that I talked about, which I think might be useful for meaningful information about the logic involved, the closed material proceedings cases draw very heavily on the ECHR in that context. So to some extent that the admin law that we have is itself tied quite closely to the two different European systems. That said, I think there is a really interesting question going forward about what is going to happen to UK data law, in the post-Brexit world. I don't think any of us really know the answer to that yet. We know that there has been a kind of complete enactment with the Keeling schedule of the GDPR as is for the time being, but there's also talk of a different national data policy, which may or may not produce something different in the future. So at that level, I think it's very much an open question. But for the time being, as I say, I don't think that the drift is quite as large as that, given that English admin law does have its origins or draw heavily on two different sources of European law as it is.
Thank you. So we're just about at the end. I want to just throw out one quick question for the panelists as well, which to some extent follows on from Tracy's question about what regulators should do, and that is this. Do panelists think that the state of the regulatory architecture gets in the way of managing trade-offs and facilitation of respect for the various fundamental rights and goals that are in play here? So in particular, we have the ICO, which is responsible for overseeing compliance with the Data Protection Act by firms, and we have other agencies like HMCTS and the Ministry of Justice that are responsible for promoting access to justice. Is there a need for more integration or a more engagement in the same sets of processes that might help to manage some of these concerns? Natalie, you've got your hand up.
I certainly think the sort of fragmentation of regulation doesn't help. However, it was really interesting. Rebecca gave a brilliant presentation at a workshop that we held looking at reforming legal frameworks around automated decision making in general. And I think sector and experts are really split on this, whether an overarching kind of AI regulator can ever have enough kind of technical knowledge of the domain area to be effective is still really difficult, I think, for us to ascertain. So in general, I think it's absolutely important that we've got that the regulators are kind of speaking to each other, and that you as a consumer or an actor know where to go to when you experience an issue with one of these products or systems. But I think there's still a lot more that we don't want to sacrifice having kind of an overarching regulator for AI with the type of sector specific expertise that the sector regulators bring.
Thanks, Natalie. Ernest, you've got your hand up as well.
John, thank you. I think Natalie's right. This is not integration of regulators that I think we're looking for, but we most certainly should be thinking about much greater collaboration at the level of development and eventually policy and implementation. In exactly the same way that tribunals and courts don't collaborate well enough together, and tribunals and ombuds schemes don't have enough opportunity to collaborate together. You've got the same dysfunction in relation to very good regulators' practice and then what's happening out there in the real world, and sometimes very good real world practice, but lack of discussion about it in the regulatory context. So I would like to see an arena in which that happens. AI has so many opportunities, but equally for many people, so many perceived threats at least, that we should be talking about what we've been talking about in this sequence of seminars, and today in particular, at that level, at the level of the regulator, the Chief Justice, the senior this, that, and the other, in order to identify what we want our academics to take forward and analyze for us, give us the options, and then see where we go with it.
Thank you, Ernest. And Jeremiah, you wanted to come in on this as well.
Just very briefly, because I think in terms of the short answer, I agree very much with what Natalie and Sir Ernest have been saying, and indeed I think I certainly haven't come across somebody who's arguing for creating more regulatory silos. I think that'd be a brave argument to run. I mean, I think one of the key challenges then, if we agree that we need more integration, how we go about it, is the very different normative goals, different areas of regulation, and therefore also different regulators are trying to pursue. right? So even just in the context of a relatively simple issue like algorithmic discrimination, you've potentially got, discrimination law trying to do something very different than the data protection law does. And this is also something we're now seeing, particularly with the discussions surrounding the European Union's proposals for AI regulation. These very different regulatory normative goals, I think, are the key challenge we need to think about much more when it comes to actually saying, how are we going to go about having this integrated regulation?
Thank you. And Becca, you want to come in as well?
Just a very quick point to say, not only do we need integration and communication between regulators, but we also need to make sure that communication is completely 100% interdisciplinary all the way through, because that's the other really important integration that's going to lead to improvements in this area.
Great. Well, I think there's so much more that we could talk about, but I'm conscious of the time, and I just want to finish by thanking all of our panelists and presenters for those fantastic contributions and making this event such a success. And thank you too to the audience for joining us and for engaging us with your excellent questions. Please remember to join us at the same time next week for our final session, which will be looking at the demand for skills in technology in the legal services sector. We're presenting some empirical research on that, and then the need for training and education for people working at the boundaries of the disciplines of law and computer science. We'll be hearing results from Becca and Tom's course in Oxford, and also engagement with professionals in professional training programs. So thank you, and we look forward to seeing as many of you as possible next week too. That's all for today. Thank you.
Thank you.
Thank you.